Supreme Court has clearly said that this power is not exercised by the President or Governor by his own discretion. The pardon is a very commonly used term for this power, pardoning power or mercy petition. But there are actually three different types. The viewers of this video may have a differing opinion, and we can agree to disagree because that is the spirit of democracy. But there is a constitutional position. And what does the Constitution say? What does the Supreme Court say in this regard? Hi friends, welcome. In Tamil Nadu, the release of Perarivalan and 6 other convicts who have been convicted in the Rajiv Gandhi Assassination case has been a matter of intense debate. Perarivalan, Nalini, Murugan, Santhan, Robert Pius, Jayakumar and Ravichandran. Out of these 6 are Sri Lankan Tamils, and Perarivalan is a Indian from Tamil Nadu. So, before we get into the details of this case and my personal opinion and what does the Constitution say about this, I wanted to give a brief history about the pardoning power. So, this power is called the pardoning power, and this has been there since the Greek Empire and the Roman Empire, even 2500, 3000 years ago. And in medieval Britain, during the 14th, 15th, 16th century and all, it was called as the royal mercy, which continues even now. And in fact, during those times, the king would give pardon or mercy. It was just to correct any wrongdoings by the judiciary. And if the king feels that someone has done some mistake which is morally incorrect, it may be a criminal offense but morally not something which is wrong, then he may give this pardon. That is the genesis of this pardoning power. So in fact, during the medieval Britain or during the 16th and the 17th century, the king used to grant pardons, and after being pardoned a convict, there were some cases where they did not want those convicts who have been pardoned to continue living in England. So they were sent off to British colonies. In fact, the states in present day USA were British colonies, and in fact that is how such convicted persons who were pardoned by the king were sent in ships, and that is how the Australian settlers arrived there 200 years back. Of course, Australian aborigines has been living in that continent for more than 65,000 years now. But these settlers from England were nothing but were all actually, majority of them were actually people who were convicted but later pardoned by the British king. Of course, this is the 200-year back history. Now the people of Australia are all liberal democratic people who live in a peaceful country. So this is the international history of the pardoning power, and this pardoning power has been there in almost all the modern constitutions. In fact, in USA there was a lot of furor over the present incumbent president, whose term ends on January 20th, 2021. He pardoned one of his close friends and aides. In fact, there are unconfirmed reports that he is considering giving a preemptive pardon to himself and his family once he steps down from presidency. But these are unconfirmed. We'll have to wait and see whether something like that happens over the next 35 days. But in India, under the Constitution, Article 72 gives this pardoning power to the President, and Article 161 gives the pardoning power to the Governor of a state. Now, I am not going to get into the constitutional and legal nitty-gritties, but there is a case called Maruram case in which the Supreme Court has clearly said that this power is not exercised by the President or Governor by his own discretion. He has to do it based on the advice given to him by the Council of Ministers, like in many other decisions under the Constitution. So the pardoning power is to be exercised by the President based on the advice of the Council of Ministers. Similarly, the pardoning power is to be exercised by the Governor based on the advice of the Council of Ministers in the state level. And the pardon is a very commonly used term for this power, pardoning power or mercy petition. But there are actually three different types of mercy, important three types. The first is what is called as pardon, which is complete mercy. It absolves the convicted person of his conviction as well as his sentence, and that person is left free. The second is what is called as commutation, where the stricter punishment is commuted, is reduced to a slightly lower degree punishment. For example, a death punishment may be commuted to life imprisonment. A rigorous imprisonment may be commuted into a simple imprisonment. And the third is what is called as remission, where the period of sentence is reduced and the person is set free. So now there are various cases which have happened in the country, relating to this pardoning power. But one case which has undergone so many changes and which has led to various judgments by the Supreme Court is the Rajiv Gandhi assassination case. So I am just going to give you a brief timeline of what has happened in the case, and then we will come to what my personal opinion is and what the constitutional position is. So Rajiv Gandhi, the former Prime Minister of India, was assassinated in a gruesome manner on May 21, 1991 in Sriperumbudur in Tamil Nadu. It's an unjustifiable act. It's a very, very heinous crime that was committed in 1991. And there were people who were arrested for this, and finally the Supreme Court in October 1999 convicted 7 people, and they are these 7 people: Perarivalan, Nalini, Murugan, Santhan, Robert Pius, Jayakumar and Ravichandran. So out of this, the first 4 people were given death penalty and the other 3 people were given life imprisonment. So they appealed for mercy before the governor of Tamil Nadu. And in April 2000, the Tamil Nadu government recommended to the governor to commute the death sentence of Nalini, and her death penalty was commuted to life imprisonment in April 2000. But the balance 3 petitions were sent by the Tamil Nadu government to the central government, and this was done in April 2000. But till 2011, there was no decision taken by the central government. See, the constitution does not prescribe any timeline for any of the matters within which the president or the governor, which means the central government or a state government, has to decide, because as per convention they are supposed to do it in the earliest possible time. But there are such cases where there is inordinate delay. But finally in August 2011, the central government rejected the mercy plea, which means they said that these 3 people have to be hanged, and September 9th 2011 was fixed as the date on which Murugan, Santhan and Perarivalan would be awarded the death penalty. But then the Tamil Nadu Assembly at that point of time passed a resolution saying that this should not be done. There was a case which was filed in the Madras High Court, and the Madras High Court referred the matter to the Supreme Court. And then in February 2014, the Supreme Court gave a landmark judgment. It said inordinate delay in considering the mercy petition is actually against the dignity of the death convict. No doubt they are death convicts, but that doesn't mean that they are not human beings. So an inordinate delay in deciding for 11 years, if you have not decided and that person wakes up every day in the morning whether I will be hanged or whether my mercy petition will be accepted, is actually against the dignity of that individual, and using its own powers. See, the Supreme Court cannot do what the president or the governor is required to do as per the constitution, neither will they do it. But they have the power to review their own judgment under the constitution. So in February 2014, the Supreme Court reviewed its judgment and it commuted the death penalty to life imprisonment. And then after that, again, all these 7 convicts filed for mercy petition with the governor, saying that there is 24 years for which we have served the jail, and so we should be released. Now again, this went back and forth between the Tamil Nadu government and the central government. The central government rejected the request once from the Tamil Nadu government, and then finally in September 2018, the Supreme Court said the governor can act as per the advice given by the Council of Ministers, because as I told you in the beginning, the president or the governor should act as per the advice given to him by the Council of Ministers in the center and at the state level. So immediately in September 2018, the Tamil Nadu government recommended to the governor to release these 7 convicts. There is one more technical angle which was said to be the reason for the governor delaying the decision. See, because section 435 of the CRPC says that if there is any crime for which death penalty is awarded and which has been a subject matter of investigation of Central Bureau of Investigation or any other central agency, then without the permission of the central government, their sentence cannot be commuted or remitted. But recently, few weeks back, the CBI has also clarified that while we are investigating the overall conspiracy behind the Rajiv Gandhi assassination case, there is no linkage to these 7 convicts in that case. So the reason why I told you this timeline is because of the multiple turns that this case has taken in the last so many years. See, Mr. Rajiv Gandhi's assassination, as I told in the beginning, is a very heinous crime. There is no doubt that it was a very gruesome assassination. But having said that, 7 people who have been convicted for that case have spent more than 28 years in prison. So life imprisonment is usually for 14 years. It can be remitted at the end of 14 years. And now this is equivalent of almost 2 life imprisonments. So in my personal opinion, the governor should remit the imprisonment, the term of all these 7 convicts and should set them free. Now, but this is my personal opinion, and some of the viewers of this video may have a differing opinion, and we can agree to disagree because that is the spirit of democracy. But there is a constitutional position, and what does the Constitution say? What does the Supreme Court say in this regard? It says that the governor is required to act as per the advice given to him by the Council of Ministers, and the Council of Ministers have 2 years back recommended to the governor to set free these 7 convicts. So hope the governor decides on the basis of the recommendation as mandated by the Constitution. And thanks for watching this video. I'll see you again with another video next week.